everyone. Good evening and welcome to the short-term rental task group meeting. It is February 9th, 2022 at 6 o'clock. I apologize if I confused anybody with my email. Thank you all for being here. We are going to pick up where we left off at the last meeting. Hopefully some codes folks will join us. Sean, there's not a short-term rental review group meeting happening right now, is there?
Those happen during the day.
Okay, so that's not bleeding over into this. So we will look for them to join us, but we'll forge on without them and incorporate their parts when we get here. So if y'all don't mind, it is just helpful to do introductions again, just your name and what group you represent, and we'll start down there next to Maryland.
My name is Britt DePriest. I'm the president of the Historic Germantown Neighborhood Association and a broker with Compass Real Estate.
I'm Marilyn Warren. I'm an owner-occupied short-term rental.
I'm George Rowe, and I'm the managing broker at Compass Real Estate.
Grace Bay here representing Nastra.
And I'm Berkeley Allen, Metro Council member at large and former planning commissioner.
Bonnell McBroom III. I'm with Metro Codes Department, short-term rental chief.
Councilmember Sean Parker representing the 5th District.
Amy Cranover representing Richland Weston Neighborhood Association.
Deborah Volley, short-term renter, non-owner occupied owner representing the 6th District.
Elise Ronzino. I've been the interim president of Nastra the past year, and I'm an owner-occupied host.
Great. Thank y'all all for being here. I have a report from codes next on the, actually review of the last meeting is the next thing on the agenda. So I sent out notes from last meeting's agenda with action items highlighted in yellow. So hopefully that got everybody inspired to do your actions. At the last meeting, we went over some legislation that had been written by the codes folks. Largest thing was new mechanisms for providing owner occupancy proof, which required 5 pieces of occupancy documentation and also requiring that those documents be submitted on an annual basis. And also allowing for affidavits from neighbors and appropriate public documents to be considered by the zoning administrator in establishing occupancy. We did talk some about ownership changes, and that ironically, when an owner, if they change legal names because of loaning practices at a bank, that can be seen as a change in ownership and they risk losing their permit, even though it's the very same people. So we talked about also some specific situations with divorced families or people changing their legal names or whatever, and the zoning administrator explained that those would not be considered a changes of ownership. We did also talk about the LLC loophole, which is if an LLC owns property. And to be clear, we do specifically spell out that for owner occupied, it has to be a natural person. So that only applies to the non-owner occupied properties. If they are owned by an LLC, if the LLC stays constant, then that is not a change in ownership if the owners within the LLC change. And from a legal standpoint, there were no options pointed out by the lawyers in the room on changing that. So if you know other lawyers and you hear of other options, to me, that could be a useful tool just for the properties that are repeat offenders that we've had a hard time dealing with, because that's largely what we're doing here, is just trying to come up with better enforcement mechanisms. I think that's what everyone has agreed to. Again, we talked about enforcement of out-of-town owners, and that codes had asked for the tool of being able to curtail services to that, and had written that legislation. We will need separate legislation specifically for the water department to do that, but we don't foresee that as being a big problem. And again, this is only for repeat offenders who have had 3 violations that have been proven all the way to the point of going to environmental court and appealing, but still not getting a change of behavior from the owner. So this is kind of a last resort, but hopefully will be a useful tool. And then We also talked about issuing permits to owners of known problem properties. Codes already has a precedent for this, of not giving building permits to builders who have a record of outstanding fines or violations. So there's a precedent for that, again, to use for repeat offenders. So we talked a little bit about state law and kind of some restrictions that puts on us. And it should be noted, I have included in our packet a bill that is currently before our state legislature that would further erode options at the local level. And that just seems really unwise because these solutions are so specific to each city, and what works in Nashville is not necessarily what will work in Memphis or Chattanooga or Gatlinburg. So our lobbyists at the state are working as hard as they can to persuade them that we really are the body at the local level that should be making those decisions for us. So stay tuned for that. What's proposed would dramatically scale back some of the tools that we have worked hard to create, and that would be, I think, very problematic for neighborhoods. So things that we still want to talk about, and hopefully we can do today, are, is there any way to deal with complaints from multifamily properties where there are multiple different short-term rental units and you can't tell exactly which one it is that's causing the parking problem or the noise problem? And I think we all decided the guest registry is not needed, that can be handled at the local level. So items that we hope to have inspirational ideas for tonight are, we talked about not advertising the whole house, and Mac, you said that's already, y'all follow up on that already, correct?
Yes, that's been in enforcement. Let me grab the date for you. That went into effect on November the 20th of 2020,
Okay.
and immediately thereafter, we began enforcing that. Now, a caveat to that is, it only applies to permits issued after that date.
And that's true for everything we talk about,
Yes.
as we know, which makes you a genius for being able to keep up with what permit each owner has and what rules they have to follow, so we appreciate that. There are 3 bills pending in front of the council that have all been deferred to allow this group, this task group of people from all different perspectives to kind of ponder whether that's the best solution or if we can come up with a better idea. One of those deals with parking, one of those deals with distance requirement, and one of those deals with a proposed short-term overlay. So I hope that that's something we can maybe get settled today. And then I had just thrown out there the idea of, do we want to talk about the number of occupants in short-term rental that's currently allowed? And if that is what's driving the problems, if it's only the 12-person properties that are an issue and we have lost a lot of other options, do we want to say we've got enough party houses in Nashville and maybe all the ones in the future don't have 12 people, maybe they have a smaller number? So hold that thought. We'll come back to it in a minute and see what this group thinks. And then we agreed to meet today. So let's talk about some of the items that we've got before us that don't deal with the stuff that Codes has already written. First, I think I would like to start with the owner notification template, and I think you have passed out a new and improved version that everybody should have on top of your pile. Thanks to the 3 people that looked at the existing letter, our goal was to add just more information about who to notify if there was a problem, in hopes that would help people deal with that. So here it is right here. So there are 2 separate ones, one for owner occupied and one for non-owner occupied. I think the only difference is simply the statement at the beginning that says I'm applying for a permit that will be either owner occupied or non-owner occupied. Is that correct? That is correct. Okay, so otherwise they're pretty much the same letter. Has everyone had a chance to look at that and see what information it provides? What we had asked for was a link to look at the regulations so that people would know what is and is not allowed, and then also communication to communicate both with the manager, who's supposed to be within 25 miles, and also with host compliance if there's something that you want to get registered with the city. Mac, anything else you want to say about these?
No. Basically, though, I do want to iterate that the any comments from the neighbors will have to be submitted in a timely fashion. There comes a time with our limited staff and the flow of the permitting process. Just to give you an idea, last month they processed 475 permits. This is 3 people. This month they've processed 474, last month and the month before, December and January, were 475 and 474. This month, there are already 40 in, and they have several that are currently being processed that are multiple units for like apartments and condo complexes. And so when those are done, they'll add 20, 40, 60 at a time, at a lick. So it's, we have to, we cannot slow down the process to the point where we lose track. And that is going to be very dependent upon neighbors who want to make comments, doing so in a timely fashion and to the correct email address is going to be crucially important.
And that's what's spelled out here as trpquestions@nashville.gov?
That is correct.
Okay, gotcha. And it says specifically, comments have to be submitted before 10 business days to be considered
Yes, ma'am.
on both of those. Any other comments or thoughts? Councilmember Parker.
Just for clarity and specificity's sake, in the last paragraph where it says neighbor comments may be submitted, could we maybe use like neighbor comments regarding this short-term rental permit application? Just so it's real clear what people are, given an opportunity to comment on there.
Well, Councilman, I will be certainly open to running that up the flagpole, but I'll tell you, it took me 10 days to get approval on what I have today, and we are submitting it to the website, and we're ready to fly. So if you wish me to do so, I certainly will, but we're really wanting to institute this as quickly as possible.
That's fine. If it's gonna trip y'all up, then don't worry about it. It's just a thought I had. So, whatever you think's appropriate there, sir.
Neighbor comments regarding this application may be submitted to the zoning administrator's consideration. We'll see.
I also think in the spirit of enforcement and trying to weed out the fraudulent owner-occupieds, I had included some extra verbiage in my initial recommendation where we specify what some of the guidelines from Metro are for owner-occupied, that it needs to be my primary residence, like calling out specific things so that if a neighbor does immediately know, wait, you don't even live there, it kind of is giving them the right information. So then when it says, this is where you can send comments, I feel like if we're expecting them to look up the regulations to even know if the owner occupied, like that would be the point of specifying owner occupied versus non-owner occupied, and then kind of including at least a few of the basics or an exact link to where they can read the regulations for that particular permit. I think that would help us get rid of some of the fraudulent owner occupieds.
And I believe I included your comments in this large pile of stuff that everyone got. I think it looks like that.
Yeah, it printed weirdly, but.
Yeah, I think that's how it came out of my,
I do think another challenge regarding this is the template will be available to download from the Metro website. We have no way to really know or enforce what people are mailing out to their neighbors? Unfortunately, how does someone prove that that's the letter they used?
Mr. McBroom, can you tell us how that works?
Yes, they cannot mail anything out other than the downloadable copies here, and they have to provide us with a copy of that.
They provide you with a copy. Is that similar to the process? I know for planning notifications, they fill them out and then actually bring it to y'all, and y'all are the ones who put it in the mail, or they just send you a copy?
No, that is the process involved with the short-term rental board appeals, the mailings that are associated with that, but they are not done in that manner for the permits.
Gotcha.
But they do have to give us a copy of what they have mailed.
Got it. Is that something, I know I had an email from an unhappy neighbor who stated that she was mailed an empty envelope as opposed, it was a registered letter, but there was nothing in it. Is there a possibility of, I guess, gathering data on how frequently that happens? I mean, if that's the one time it's happened in 7,000 permits, maybe we don't need to change the rule for it, but have you?
I don't
are
think
you
we
aware of
have
that?
any mechanism or vehicle that will collect that data, no. But now, I will say though, with the number of permit applications that are being processed and the thousands and thousands of mailings that are associated with it, and the staff that we have, I really don't know how we could keep on top of that.
Gotcha.
I mean, those types of things I'm sure do happen, but I think they're anomalous.
Gotcha.
Is there any thought to including the owner phone number? I know you have the owner phone number or the responsible party. Maybe including the owner phone number up underneath the address on the top of the letter, and then the responsible party in the body of the letter. So they have both sets of contact info.
So in the items at the top that are in brackets, insert date, insert name of property owner, adding the phone number as well?
The owner phone number, and then
Gotcha.
he can put they can put either the owner phone number or the representative phone number down in the body of the letter.
Well, all of that information is public information and it's available on our Nashville portal, but we really wanted to emphasize the contact person because that's the individual that has to be within 25 miles of the rental unit when it is rented and has to have their phone on 24/7.
Sure.
A good chance that the owner, if you call them, they won't have their phone on or they're out of state. It's just, now of course, depending on owner occupied or not owner occupied. But even with the owner occupied, because as I stated in the last meeting, one reason that I think that there has not been a requirement that the owner occupied property permit be present at the time that the property is rented is because of the influence of the music industry. We have folks that it's their residence, it's their domicile, they're traveling, they're on a bus 6 or 8 months out of a year, and they're entitled to have a short-term rental permit according to the state law, and so therefore, you know, it's just, in our opinion, and believe me, we had a very detailed meeting on all of the changes that were proposed, and we wanted to put the emphasis on the person who has the responsibility to answer the call at the time that the property is rented.
But if both phone numbers were on there, they would have 2 options to call.
Yes, but what I'm saying is, the focus should be on the contact because they are the responsible party.
Ultimately, isn't the owner responsible? I mean, ultimately, isn't it the owner's problem? You know, he's hired the property manager to manage it for him, but kind of like the buck stops here number. Yeah.
According to the Metro ordinance, any violation of the Metro code, the owner bears responsibility. But the way that the ordinance is written, the contact person is the person upon whom the emphasis is placed, and we really wanted to keep it there.
Well, I mean, you could put that number in bold in the body of the letter, but I don't see the harm in having the phone number of the owner.
Well, I will certainly be glad to mention that, and I assure you that in our meeting it was discussed. And what I have for you today is what was approved after a very long discussion of all of the suggestions that were made. I can make changes. It's just going to delay the implementation of 2 to 3 weeks.
Other comments on that suggestion? I appreciate that discussion. I think it's worth running up the chain if we can. Okay, so what we're asking is in the heading to add the phone number of the owner as well. Simply so that it's available to the, and then, Elise, I'm looking at your comments on, for the owner occupied, what was suggested was a statement that says, I intend to follow all regulations. Let's see, as he says, I intend to follow all regulations and ensure that my tenants comply with all regulations. These include verifying that I permanently reside at the property through documentation, advertising the rental as an entire home, renting to a single party of individuals at any one time, maintaining smoke alarms, enforcing all noise restrictions and waste management provisions contained in the code. That seems useful for both of them. So you had just a different list for those as well. Okay, so we have a discussion about that. Does everyone see the comments from Elise, which had been sent out? Simply to give neighbors some indication of what the requirements are.
I do think there's some, validity to, especially for the owner occupied, the weeding out the people who are illegally, fraudulently getting those permits. Yeah. Because the neighbors know if they live there or not, but like she was saying, Elise was saying, I don't know that people are gonna look up the regulation when they get that letter. If that specifically is spelled out, this is my permanent residence, the
Yeah.
neighbors can help weed those out.
Gotcha. So those are, okay, so it's those two, and then for both of them, you have the single-party smoke alarms and noise and waste management. Other comments on that? Do people agree that that's the appropriate list and that including it would be, there's definitely room on the letter. And Mr. McGrew, did you get a copy of that in that big packet that's at your space? There's
I have it.
Okay.
I reviewed it today.
Gotcha. If we could run that past I think this group feels like that is more important than the immediate change to the website. If you could just have the group discuss it again.
Again, I will reiterate, and I certainly will take this back to the zoning administrator, but every one of these topics was discussed at length, but I certainly will tell them the task group's feelings concerning this.
Okay. I think that's what we asked for. So comments from Sean and from Elise. Anything else on the notification? We appreciate the work that all of y'all have done on that and your willingness to do a little bit more if we can help that notification letter to make a difference. I think that's worth the effort on that one. Okay, website revisions. Any other comments on the website in general?
I'll also add that we are looking at the possible change to the affidavit. We are looking at some wording to the effect of I certify that the STRP for which the permit is issued will comply with the Metropolitan Nashville Davidson County STRP ordinance in effect on the date of issue.
And can you tell us how that's different from what's there currently?
That is not directly addressed on the affidavit.
Okay.
It just, it has certain certifications to which they attest and certify, but that just is not among them.
Okay, so you're adding that one to the list of things that they certain.
That would be correct.
Great.
Now, it's under consideration. It's not definite.
Okay. That seems like useful information and worth doing. Any other comments on the website? No? Okay, good. Okay, noise detection requirement. I had thrown out a possible, and you can tell the difference between when Mr. Hargis writes legislation and when a council member who's an engineer writes legislation, but this is my bumbling attempt. Let's see, it looks like this. It has highlighted, means maybe there's some more work we're going to do on the language there. I think ultimately what we probably would want to do is roll all these into a single bill, unless some of them are controversial and some of them are not no-brainers, but so far I think we're all on board. So right now, the short-term regulations are divided up into two separate parts. And so depending on where you land, you're either in the owner-occupied rules or the non-owner-occupied rules. There had been a discussion about noise being one of the problems that we have. It tends to come from larger houses that are being used for parties, which tend to be the non-owner occupied. And so my suggestion here that I have tried to draft up is that we add a section that says, in addition to saying, as it does already, all STRP occupants shall abide by applicable noise restrictions and regulations regarding the public peace and applicable waste, I have added a sentence that says, noise monitoring shall be provided by the owner, included but not limited to a noise detection system capable of alerting the owner and/or responsible party to sound levels which are audible at the nearest residential property line. The audible at the nearest residential property line is the Metro noise ordinance standard already. And my assumption is that a manager could, quote, calibrate the thing inside to set it at a level that, you know, when the music inside gets this loud, I can hear it outside, and that's when it's going to trigger the owner. So I think that is a better standard than trying to make some statement about decibel levels or anything like that. I mean, I've heard the statement from some of the folks who are owners that most of the responsible managers now are putting these in regardless, and that they are very helpful in preventing problems from happening in the first place. So I just would welcome a discussion on if this is something we want to consider or not. I see a hand over there and maybe another there, so.
I was just gonna say, I think this is great, and it really helps an owner, because if they do get a complaint, they actually have something that can say, actually, no, we weren't noisy, or yes, I see here they were, and so they can give that information and actual data to codes or whoever is, you know, responding to the complaint. So it's a protection for owners as well as the neighbors.
That's good information. Other thoughts? Were you raising your hand, John?
Yeah, I think the one concern that we would have is that just it would all come down to how the language is fashioned, and that it doesn't turn into being construed as a requirement to get a permit that you have to have a noise detection device.
I will say that's how I'm in it, but I'm open to discussion, and if you can think of what the circumstances would be.
Well, I don't think that it's a pervasive problem across most of the short-term rentals. And obviously there are some that have issues with them, and I think we know kind of what the basic construction of those are. But if you have a 2-bedroom, 2-bath in a quiet neighborhood and you've never had an issue, I don't think it should be a condition to get a permit.
Any thought on whether it would make more sense only for 3 or 4 bedroom? Would that make it make more sense?
If I might just interject, I did a quick Google search of the systems that are available. They, right now, range from $129 for the monitoring equipment to $149. Most of them have discounts anywhere from 25 to 80%, and the monthly monitoring fee is $7.99 to notify you on your smartphone at any time. I think that's a very reasonable cost, and I don't think it would be an undue burden.
That's helpful information. I appreciate you looking that up. Other thoughts?
I do still agree that to make it be widespread across the board, owner occupied as well as non-owner occupied, or even the smaller units where it hasn't been a pervasive issue, does seem a little punitive, and needing that in place for the application of a permit means spending all that money for a permit that you may not get for whatever reason anyway. So like, I don't know that should be a requirement up front, and if it's needed after you've been permitted, how is that proved or enforced at that point?
Ooh, that's a good question. So I will say this is, where this is inserted into the code is the non-owner occupied section. So it does only apply to the non-owner occupied. And it is in the section, I believe, that's not the application part, but the how you operate part. However, you raise a really good point about then how do we know whether you have that or not? So further thoughts on, again, I mean, we're just trying to solve the problem of the house where noise is a problem for the neighbors on ongoing basis.
I have a question just about the practical aspect of it. So let's say that these were in all of the short-term rentals and one of them spikes. What then? You know, like what has that accomplished?
When it works correctly, when it spikes, it calls the manager, and the manager calls the place and says, did you realize how loud you're being? And tenants say, oh gosh, no, sorry, we'll be quieter. In a perfect world, that's what it's supposed to do.
Right.
There are other scenarios that you can imagine that would play out differently, but that would be the purpose of it, is just to allow a way for the manager to know before the neighbors know that things are getting a little rowdy.
To head it off before there's a neighbor complaint.
Correct.
Okay.
Which, that's not a bad thing.
Right, no, I agree.
I can tell you that it is really widespread and rather pervasive, and the problem is that we do not have police powers or enforcement, and the Metro ordinance says that noise complaints will be handled and enforced by the Metro Police Department. Now, we all know the challenges that the police are having right now. We also realize the majority of the time in which these complaints come in, there may be other priorities that are higher on the scale than noise complaints. And as I said in the last meeting, and I'll say again, the way that these are handled, they don't differentiate between short-term rental properties and other noise complaints. They go to the property, they ask them to quiet down. If they do so, they don't file a report, they don't do anything of the nature, they don't file a report generally until they come back the second time. And then, of course, if they see anything such as a drunken disorderly or anything of that nature, they'll make an arrest, no matter whether it's first or second time. However, it's really difficult to enforce at the time at which it happens. So anything that we can do to mitigate this would be a huge advantage.
So can we talk about language that would encourage them without requiring them? Any thoughts on that? Is that a preference? Other thoughts? Mr. Parker?
I guess, I don't think that the like problematic properties that we're most concerned about here with the gunfire and the parties and whatnot, I don't think those folks are going to take a suggestion to heart as to how they should better monitor their properties. That's my only thought about sort of making it a suggestion.
As opposed to a rule.
That's what I was gonna say too. It's a small hurdle for someone who is following all the steps to get their permit. I don't feel like it's a really tough requirement, but I do also feel like all it's doing is putting another requirement on the people who are following all the rules, and the people who aren't following the rules still aren't gonna do it. But if it helps mitigate the problem across the board, I think it's, $150 can help solve and make some happier neighbors, and I think responsible owners are happy to do that.
Good point. Ms. Crownover.
Yeah, from a neighborhood perspective, I think it relieves the neighbor of the awkward burden. They're going to have to go look for paper and figure out who to call, or they're going to call the owner. And that is often something I know from my own neighborhood. There's a lot of hand ringing before you place a phone call. And then by the time you do, people are pretty pissed off. So I think this, again, it not only eliminates perhaps work for the police department, but that inconvenience to the neighbor.
Got it. Other comments? And I'll just interject kind of some process here. My thought is that this group is fulfilling our initial function right here, which is to try to come up with changes to the current rules that will hopefully make enforcement work better and operation work better. And then step two is for each of us to go back to our interest groups and say, here's what we've done, what do you think? So this may be one of those things that we take back to our interest groups and ask that question. And then maybe before we file, we come back again and discuss comments that we got from a wider audience, or even do that, check with people in the next week or two and bring back thoughts on that one. What do you think? Okay.
So in looking at the complaints that were sent out a couple of weeks ago, noise complaints, there were 1,100 over the past 4 years, documented noise complaints, which was about 18% of total complaints. So in talking about it being a pervasive issue, I'm not sure that 18% is pervasive. And in terms of trying to move away from being a punitive action against people who aren't having these issues, or a smaller unit that, you know, haven't had these issues, maybe we could think about some sort of requirement or suggestion for people as they renew their permit if they've had a certain number of noise complaints over the past year.
That's a good suggestion.
Yeah, even having one noise complaint could trigger a requirement now, or something like that.
That's good point.
What would be appropriate evidence of ownership of noise monitoring? A receipt, a photo of it?
Ooh, Mr. McBroom, can you?
The first thought that pops into my head is it could be, especially on multifamily units, which probably lends itself more to these types of complaints. We could ask the fire marshal to incorporate it in their inspection. A recent change that is in the process of being instituted is that the fire marshal will no longer be performing the inspections on 1 and 2 family dwellings. As it was explained to me, the original intent of the ordinance was for those inspections to be handled by the certified Tennessee licensed home inspectors. And the fire marshal at the time felt that he wanted to handle that, and at this point, given all of the inspections that they're having to conduct, they've asked if we could relieve them of that, and we found that to be reasonable. And so we're going to be going back to Tennessee licensed home inspectors on that. We've done an in-depth study of the current code adopted for Tennessee, which is the 2012 International Residential Code, and then for Metro we have the 2018. We can't safely make the assumption, since the home inspectors are licensed by the state, that they will perform 2018 code level in Metro. Nonetheless, after an in-depth study of both codes, we've come to the conclusion that all of our requirements are met under either the 2012 or the 2018, so we're covered there. However, as far as getting the home inspectors to add that to their list, I'm not sure that would be successful.
Well, and the suggestion to do it after a violation, I think that solves some of the problems that y'all have raised, which is a good point. And that would be at a different time from when the home inspector was doing that anyway. So I think you raised some good issues about how that might be difficult to ask them to do, and it may be the wrong time anyway.
We would still have to develop a mechanism for certifying that it has been installed, but it would be on a smaller scale, and it would be on a incident-specific.
Gotcha. Okay, so I'll take as a homework assignment to redo that language, to incorporate it as a follow-up to a violation, and then work with codes on figuring out how that could be documented afterward.
I feel like something like this is probably going to do a lot toward, as a neighborhood organization, the primary complaint that we hear about short-term rentals is noise. And it's probably bigger than all the other ones combined. Now, we don't keep statistics on it, of course, but that's what we hear from people. So I think that adding something like this to the requirements, and also just increased education about host compliance. I didn't know about host compliance. No one that I've spoken to in my neighborhood knew about host compliance. They always handled noise complaints, as they've always been told to do, through the police. And there was never any reply or anything done about it, So I feel like any way that we can push information about host compliance and then make sure it works like it's supposed to when people use it, combined with something like this, I think may go a long ways towards making people more comfortable.
That's a good point.
Yeah.
I also had something. Does any of this have to do with the number of people that are allowed to be in the space? I mean.
Well, I will just say, I've lived across one that can have up to 4 people. I mean, it's a 2-bedroom. I guess technically it could have up to 8, but it can have 12. And there has never been an issue in 6 years now.
I mean, I was saying, say, if
Is there-
these properties are being used as an event space of some sort, like frat party or whatever, is there?
That's not allowed anyway. You're not allowed to
I
have.
think that's what the problem is.
Well, that's what I'm saying.
Maybe it
Again,
happens,
it's
though.
not responsible people who are,
Yeah, well, I
allowing
agree.
that.
Getting
It's
people,
a-
making
it's
people
the
responsible
problem,
is
for sure.
job one.
Yeah.
Exactly. I think there is more, I think there is a correlation with more guests probably. But I think the suggestion to have it as a consequence of a violation probably makes better sense even than just basing it on the number of bedrooms, which is kind of where I was thinking. I think that's a good suggestion.
And excuse me, go ahead.
Ms. Crono, did you have something? Okay. Mr.
And
Rickard.
one thing too, that even the noise mitigation equipment will not address is the rooftop parties. But anything that we can get to help with this, I think would be a very good measure. I certainly appreciate your comments, because I can tell you from my experience, we receive a lot of noise complaints. Now, as far as the host compliance hotline is concerned, we certainly publicize that very, very strongly. At the end of the day, though, all we can really do is send them a letter, which is good because it's in the record, and when they receive that, when the host line gets that, then they contact the contact on the permit and make them aware that there's an issue, which is another good thing. But at the end of the day, it has to be addressed by the police, because we don't have policing powers, and we can't prosecute them in court for noise unless there's an arrest made and a subsequent conviction. So it's anything that can be done to assist with this will be a big help to a lot of neighborhoods in this
Gotcha.
community.
Well, I mean, this seems like a good next step to try then, I think.
But if I understand host compliance correctly, then you call them, they call the property manager,
At
and
that
they
time.
do what it takes to remedy the problem up to and including the property manager coming out. Am I correct about that?
That is the way it is supposed to work.
Does it work like
Absolutely.
that?
It depends on how responsible the property manager is. And I'll tell you, as I said last time, some of these people are, fly by night, and they're not very responsible. But the majority of companies are in this business to make money, and I can tell you, there is money to be made. It's lucrative for the property owner as well as the manager. But the only way it remains lucrative for the manager is if they have a good reputation and if they handle issues, because if the owner has to come back, he'll fire them and get another one.
So is there a way to address it through licensing a short-term rental property manager? Where if host compliance
You do
gives
have to
them a
have a
poor
license.
grade,
That's
then
a state level issue, isn't it? I mean,
They have to have they do have to have a specific license to manage short-term rental properties. It can't just be a regular property management license.
so is there a way for host compliance to give them a report card or a score or something like that? And if the property manager is not responsive, then,
I don't know. That's a good question. I feel like people do change their property managers when they're not working correctly, and so I don't know how easy that would be to know who was managing the property at the time of the complaint.
it would be
should
whoever's registered. I mean, they should know who the property manager is, right?
Right. I don't know. I'm just saying, if someone was managing the property, they got a complaint, and then there was a new property manager,
Mhm.
like just making sure that new manager didn't get the strike.
I guess the property manager would need to report to host compliance. I'm no longer managing X
Well,
property.
They do change it with codes.
Mhm.
I don't know how you track it. I think it's a good idea.
Yeah.
and is it the real estate licensing board that permits them or
It's TREC.
it's TRIC? Okay,
Tennessee
Real Estate Commission.
gotcha. And is there a way to work with them? I mean, is that a
I mean, it's
Tennessee
part of
thing,
their-
Tennessee real estate?
Class that they take, their training, I don't know. I haven't been through that class because
Gotcha.
yeah.
I mean, it would be handy if the real estate folks in here could just communicate with them and find out, just if we can optimize their response, or just ensure that if it's not a good response, that perhaps they have some mechanism in place to make sure that that person doesn't stay in that position for very long. Okay, so that was a homework assignment. I see people writing it down. Great. Awesome. Anything else on the noise detection, Amy?
Quick question. So when you mentioned rooftop parties wouldn't be impacted by this, do these noise detection systems, I guess specific to our neighborhood, people, the noise is happening outside. So is that gonna trigger something like this? It's happening, on the front porch, on the streets. It's kind of like the gathering, the hoo-ha, the yee-haw, we're back.
The only way that, that could actually be legitimately addressed is if by ordinance, they were required to have indoor as well as outdoor equipment.
I mean, and technically what the noise ordinance says is amplified music can't be audible at the property line. That's the standard. So unfortunately, people having a great time and laughing and shouting is actually not covered by the noise ordinance. And I'm sure that the detectors can't distinguish between that, but I think we can still, for the benefit of the neighbors, ask that they have something that monitors when things get audible at the property line. And we have a legal case if it is amplified music that is audible, whether it's coming from the front porch or the roof or inside. And I think you just plug these things into a receptacle.
Yeah, as Director Herbert mentioned, though, it has to do with decibel levels, which it says 85 decibels.
Nope. That's live music downtown, but the residential noise ordinance in Chapter 9 simply says amplified music can't be audible at the nearest residential property line. And that's easy.
That is true.
And I think that's what applies in most cases. When we're on multifamily, that's a different animal, maybe. Like if you're in a condo, I'm not sure where that falls, so I will defer to you on that.
Also, well, the property is, you own stud to stud, so if you can hear it in the adjacent property, then it's across the property line.
Gotcha. Okay.
In addition to that, the downtown code is very lax when it comes to that, and
That's true.
We have numerous not owner-occupied permits in that area, so it still would be a way to address it, at least to get the property manager to realize that there's an issue.
Right, that's a good point. You're right, the downtown code is a whole different set of rules, and I agree with you on that one.
Let me add this one thing to it. It's possible that there are classes of these units that it just makes sense from the beginning to have this, for lack of better characterization, the short-term rental hotels. There's one on very near Centennial Park. It's really out of character for the neighborhood. And so the point I'm making is, if you've got 12 units in it, how do you know is creating the problem? And therefore, I can see some logic there to having that be a requirement so that whoever creates the problem, a bunch of people are sicked on it to do something about it. And the other thing is, I think that we do know that anecdotally, most of these issues come from units where there are 10 or more people. I don't know why 10 people is critical mass, and I think that we probably have that same problem repeating in a fairly finite set of properties. So maybe there's something to look at there.
I think that's a valid point. And I think the suggestion to tie it to a violation as a starting point, I think is a good one. So let's go down that path if people feel like that's a better way to handle it than simply
having it as a
requiring it.
consequence is a good thing, and there's a reason to do it.
Okay. I think that's good. I appreciate the good discussion. That does get us to the next two things, which are complaints for multifamily properties. And again, I think if we can't determine who in a multifamily property the complaint is lodged against, can we just tell everybody we're having a problem in this multifamily, and it would help us tremendously if you all have a noise detector, and then you can.
Would there be a way to engage either the HOA or the the overall property management firm, because any of these multifamilies, there's a complex property manager that isn't the short-term rental management. They're dealing with the units and the homeowners and all of that. If we could,
Always?
yeah.
Okay.
Yeah.
Okay,
So if we could engage them when there's an unknown, then it's just, hey, your whole building has become problematic, so you need to figure out what's going on. And then, I don't know what that looks like on their end, but it
Gotcha.
creates some additional responsibility for the other parties involved.
gotcha. Is that something, that solves a problem that I've been called about recently, so I'm gonna take that to heart on that, which I appreciate. In terms of writing anything into the legislation, does that seem appropriate? Let's just learn on that one, and if we discover a really great way to deal with it, then.
Yeah, it seems more like an enforcement practice versus a legislative issue.
Okay, I'm good with that one. Okay, and then, officially, we have like 6 minutes, and I want to get to the 3 pieces of legislation. I did throw out the thought, do we want to talk about 12 people maybe not being what needs to happen? So hold that thought, and I'm going to assume that we're going to have to meet at least one more time, but I think that's too big a discussion to have at this point. But there are 3 pieces of legislation. I think probably the most controversial one, so maybe we'll take that one up first, is, or at least begin our discussion on it, is the parking requirement. And I did send everyone during, I think, early after we met last time, the parking table that shows up in the land use. It's like several pages long, and it includes for residential property. It looks like this. I'm not sure if anybody printed it out, but it goes on and on forever. And it talks about every kind of piece of property, including residential land uses. The way the parking bill is written, the way the short-term rental parking bill that is pending before the council, it's been deferred, waiting for us to do our work. So if we have a better idea, I think the sponsor is willing to listen to that. But what's currently out there is that it says, rather than just a single-family home has to have the same number of parking spaces as what this table says, which is 2, it says that short-term rentals have to have the same number of parking spaces that a hotel would require. So if you have 4 sleeping rooms, is the language that we use, then you would be required by the hotel category in the table to have 1 per sleeping room, which would be 4, which, and the reason I sent you this whole table is if you go all the way to the back of it, it has some extra parts to it that say, if you're in the downtown code area, then you don't have to have any. If you have on-street parking, then you can count that for half your parking. If you can specifically make an arrangement for off-site parking, you can use that. So there are a number of caveats. You can reduce by 10% if you're within walking distance of a transit line, and there are enough 10% reductions that you might be able to get rid of from 4 down to 3. So it is not necessarily the hard, you have to have 4 everywhere there are 4 bedrooms. But there could well be places where that's what you've got, and that's what you have to do. So I would welcome a discussion on how we solve the problem of people parking in neighbors' yards when inadequate parking is provided. And if having all these, caveats in the code provides enough flexibility that perhaps once everyone learns about it, they'll be more comfortable with it or not. So, Deborah.
I just had a clarifying question about the hotel motel requirement. It says 1 space per rooming unit. So what I have heard other people mention is that that's like a hotel suite with 2 bedrooms. That's only required, that's only considered 1 rooming unit. And so I'm not sure if that's correct or not.
That's a good question. I need a codes expert to help me out here. And Mr. McBroom, if you want to defer to Mr. Hargis and Mr. Herbert, we can.
Yes, hotels are actually out of my purview.
Gotcha.
I think, well, I know that their inspections, I'm not sure if it applies to the rooming units, but the health department carries out their inspections.
So it may be that somewhere in Chapter 17, there is a definition of hotel rooming unit that will make that clear, and I just don't know what that is. So I think we need to do more homework on that question. And I think keep asking other questions, but I think that's an important one to, I'm gonna put that on my list. Check on definition of hotel rooming unit. Other comments or thoughts?
I think that the genesis of this bill started with discussions within the Germantown Neighborhood Association.
Yeah.
We had a small group after the rezoning of the neighborhood failed. Freddie got together a small group, and it was myself and another member of the neighborhood. It was a real estate developer, and then 2 short-term rental owners. Now, this was not a recommendation of that group, but this is where this idea came from. And the thought that led up to this was a non-owner occupied short-term rental is being treated like a single-family home, which it's not. Now, maybe it's not a hotel room, but it's definitely not a single-family home. We had the development that sparked this in Germantown was, I think they have 13 non-owner occupied short-term rentals in the same development, and maybe 15 parking spaces, maybe 14 parking spaces. And these are mostly 4-bedroom. I think there's some 3-bedroom in there. It's really underparked. And the residents that live around it, they have parking spaces in their homes, but they do rely on street parking as well. And nights when this is full, the parking, according to them, just goes away. So I think we're just looking for a way to decrease that somewhat.
Yeah.
I don't know if treating it, 1 space per bedroom is the way to do it, but I think there needs to be something.
More than what we got.
Yeah.
Good, okay, thank you for giving that context.
Sure.
Spade?
I just want to ask the question, since we have made such a change to where non-owner occupants can even exist now, do we feel like that might solve this problem in and of itself?
No. Germantown doesn't.
Okay.
Yeah.
Okay.
Germantown has a lot of mixed-use zoning.
Okay.
And so currently, that is where the short-term rental non-owner occupied is gonna flock to. So that's a really important point to make. Ms. Runzing?
Is there scope to focus this in on multifamily complexes again then? Because once again, that seems to be the most problematic issue.
So, I don't know is the answer to that question, but I think if you play it out, if you had a home built on a 50-foot wide lot with alley access, then you would think that they could provide 2 or 3 parking spaces behind that home. But you can't guarantee that, unless you require that. So, yeah, I don't know.
I also struggle with this one because I keep coming back to the number of complaints about parking. The complaints aren't there. And so again, I agree with you. There is definitely a parking problem in Germantown area. So I don't know what the solution is without hurting every single other area with this, with making some sort of overall overarching legislation that really does affect a lot of people, especially developments, even just under construction right now.
Can this be put together where it just applies where there's a problem as opposed to the entire city?
Can you think of a way to define that?
Is it the
Councilmatic
multi-use
district.
zone? Is it the multi-use zone? If that's the
Is
biggest concern.
is that a mixed-use zoning area there?
Or mixed
Yeah,
use,
most
rather.
of Germantown is zoned MUN or MUL, yes.
Gotcha.
Yeah, but again, that's the only place where you're gonna go in and build new non-owner occupied short-term rental units. I mean, unless you have CS or some other commercial zoning district.
Gotcha. Mr. Parker?
On the subject of the parking stuff, so I have heard that, there's not a lot of complaints documented supporting this. I mean, I've lived on blocks where there were a disproportionate number of short-term rentals, and I mean, I can't, unless I sit outside on my front porch, I can't tell you that the rotating cast of out-of-state cars are staying at a permitted Airbnb unit, and which house they're in, and so it's not a complaint that I could effectively make, right? So I think that's part of why we're not seeing the volume of complaints specifically going into host compliance about that. Most people would complain to Hub or to me when they have parking issues in their neighborhood. And also, you know, speaking about some of the multifamily development, the mixed-use developments that are short-term rental oriented, or all short-term rental, you know, what we see in a lot of them is they're satisfying their parking requirements with garage units, like 2-car garages in the rear of the property. And I mean, if you just go look around on the Airbnb listings, you'll see a lot of those garages are game rooms or
Right.
you know, dens or you know, they've put a bar in there and a pool table, you know, which is cool, but it's no longer a parking area at that point. So you know, some of these, and the thing too about the parking just generally, you know, we've got a lot of these all Airbnb complexes in my district now, and you know, I'd say 4 nights out of the week, it's not a problem. But a busy summer Saturday, all of a sudden you've got like a small street that is just encumbered with out-of-state vehicles. You know, we've had to be a little bit reactive and you know, doing some resident-only parking in areas, restricting parking to one side just to allow streets to be traversable for the residents. Yeah, those are just all my thoughts about the parking thing. I think there's a lot to it, and I'm not sure what the best approach is, but you know, I don't know how you stop people from putting a pool table in the garage after codes has said this qualifies as your parking. I don't know how you do that. So I don't know.
Well, to your point, could that be the creative roundabout solution? Is that something that could be enforceable? When you turn in your building plans, floor plans to get your permit and it shows there's a garage, that has to be required parking. You cannot turn that into
Well, but I mean, like
living space.
Well, but I mean, I know a lot of people who've, you know, lived car free. I've lived car free in this city, and I mean, I don't think it's something we want to put across the board. Like, I think it would definitely be tied to a permit.
Yeah, that's
if
what I
they were
mean, for
gonna
the
do it.
short-term rental
Yeah,
permits.
Yeah, I don't think we should change the. Yeah, I think we're in agreement there. I just wanted to be clear about that.
Yeah.
If somebody wants to ride the bus or a bicycle, they don't have to keep a car park. Yeah, or their home. Yeah. So that's maybe just the kind of a.
Yeah, I mean,
Brain
I've heard,
dump there, sorry.
I've heard exactly all those very same issues in the Hillsborough West End neighborhood district as well. So I mean, I
Yeah.
think it traverses at least 3 different parts of town.
Yeah, I'm expecting a huge influx of people. I see it all the way down there into the fairgrounds, of new buildings and stuff like that. When the soccer field opens,
Mhm.
I can't even imagine what it's gonna do. I mean, I live on Allison Place, and everybody's been down Allison Place on Wedgewood. You can't get a car down except right through the middle of the street.
Yeah.
Other car has to move over. So we have a parking problem now, even without all of this other stuff. But there's so much stuff going on, especially down toward the fairgrounds, and you know, it's gonna be absolutely crazy. It's crazy when there's flea market.
Right, and that's a
So
different
I'm
thing.
interested. I don't know how we solve these problems, because this has nothing to do necessarily with short-term rentals, although I suspect that all those things down there are short-term rentals. But I'm interested in the solution for this problem, because we can't get down our street.
That's right. Well, put your thinking caps on, Ms. Bay.
Do we think that part of the solution could be some resident-only parking, since it seems like there are really specific areas that are affected by this problem, rather than requiring all permit holders to have this moving forward? Maybe we could focus on those areas and implement more resident-only parking, because to your point, it's not only short-term rental people who are, you know, visitors who are taking up that parking. There are certain areas that I think have other issues too.
I think that's another option to explore. I will say, I live in an area that has a fair amount of residential permit parking, and that's only as good as the enforcement, which doesn't happen at night. Which is what this problem is.
It's also, anytime that we have that conversation about restricting on-street parking usage, it's a balance between like the businesses in the neighborhood and the neighbors. So it's I wouldn't want to sort of shift the burden straight onto neighbors and businesses in the area if we feel like this is being driven by, you know, short-term rental, which again, to me, the big challenge about this particular issue is that 4 nights a week, it's not a problem really. But
And if the group all uses Uber to get from the airport, it's not a problem that weekend, but it may be the next weekend, you know, when the
Well,
group all drives in.
When you, I've heard that argument, but when you have a 50-unit complex, the odds that
Right.
the majority or half or of those people are gonna all pick to use Uber that weekend are very low. You're gonna have a mix, and even then, it's,
But if that complex is no longer, let's say it's no longer a short-term rental complex, but now 50 people live there, isn't the problem like still there, even if it's not a short-term rental? If you have a 4-bedroom townhome and there's, 4 bandy kids living there together, and you have 4 cars, I just don't know that the short-term rental piece of it is the actual problem, if that property then starts to be used as something else.
I think the thought is there's going to be more people in a short-term rental than there will be in a home. So if there are 4 Vandy students in a 4-bedroom townhome, yeah, that might happen, but it's probably more usual for there to be 3 or 2. Whereas with a
But not
short-term
12.
rental, there's 8,
Right.
10, 12,
I just don't know if it's commonplace for, let's say it's a 12-person short-term rental for 12 people to drive. Even if they all flew together, or maybe there were 3 groups, there's still, I just don't ever see 12 cars. I just don't ever see more than 3 or 4 cars in that circumstance.
But even 4 cars would be twice as many as your normal
Yeah.
home.
I don't know. I have
you know.
4 cars at my house. Like, we have a teenager who's driving, my husband has a work truck. I don't know. I have to have a minivan because I have 4 kids.
It is definitely not unique to short-term rentals, but.
I'm the problem.
So we just have to restrict your number of
Right,
cars, yeah.
right. Just
There you go.
stop making babies.
But, I think you're right, it's not unique to short-term rental, but there are certain neighborhoods where there is a problem, and that particular problem is being caused by a short-term rental. So is there a way to require, property owners to instruct their guests something about parking?
just generally in my view, sort of like you say, the resident only is only as good as the enforcement. The layers of, asking people to inform people about the proper way to do something. I have a lot of friends who have, hosted Airbnb, and it doesn't matter how clearly you put, here's the code number, here's where the key is, here's that, they call you, they say, where do I park? How do I get in? So, I don't know that just, again, these nudges to sort of ask people to do this, that, or the other are gonna do much, just in my experience.
Valid point.
Maybe it's a question for the short-term rental groups. So a 4-bedroom home, you feel that 4 parking spaces is unreasonable. What's reasonable? I don't think 1.5 is reasonable. I don't think 1 1/4 is reasonable. But if 4 is not reasonable, what is? And I don't need an answer now, but if we meet again, that might be a good thing to know.
Or in a multifamily unit, is there a way to work through the HOA to say how do these spaces get shared so that everybody's going somewhere? I don't know.
Or is the approach possibly to not apply parking reductions that exist in the code already for short-term rental units? So if you're in the UZO, if you're in this side or the other, you're in, there's, all the, on a bus line, et cetera. I don't know them off the top of my head, but to say that these wouldn't apply in this case. So it is just parked by the book.
Well, and I think that's what is currently being assumed as what is required.
With the reduction.
With the reduction. I think that the people who are the most concerned about this are reading this as a 4-bedroom unit requires 4 parking spaces everywhere. And that's not necessarily the case. And I don't know that the parking reductions, if we tried it on for size in the Germantown example, I'm not sure how many you would be reduced, but.
Well, I think maybe Sean was saying something that you heard, so right now, if I build a 2-bedroom housing unit, I can take advantage of certain reductions. I'm sorry, a 4-bedroom. It means I don't have to provide 2 spaces. I can provide 1 space. Maybe apply those bonuses to residences, but not to maybe apply those reductions to residences, but not to short-term rentals. And that would mean a 4-bedroom townhome would probably be required to have 2 parking spaces. Is that what you were saying? I mean, did I hear you correctly?
Yeah, and it's hard to really speak much about this without, having somebody who's super familiar with this, that we can just be like, what would this be in this
Yeah.
case, and what would this be in this case? So, I don't know, this may be, it sounds like we're on track for a fourth meeting of this.
Sounds like we are.
Because I think the 13-unit development in Germantown went from needing 26 spaces to needing 14 spaces or 13 spaces, however how many they wound up with, because of those reductions.
Well, and again, how many of those
gotcha.
are two space, underneath the rear of a unit, which.
None.
Oh, okay, well,
Yeah.
in a lot of cases, the patterns that I'm seeing include that, and then as I
Right.
said, they get converted into game rooms and whatnot, which is fun, but,
Yeah.
it's not a
But it's not
parking
parking,
space.
right, yeah.
So your specific case, which is what has driven all this, provided, and I'm looking at multifamily housing requires one space per bedroom up to 2 bedrooms. So if you're 4 bedrooms, that's still 2 spaces. No, let me keep going. 0.5 bedrooms per bedroom for each additional bedroom. So that's one of the reductions is for a 4-bedroom, it would be 3 spaces.
That's right. And then if you read further, like you said, they have street parking, they're close
Right.
to mass transit, so you reduce. And they got down to, I don't know what the number is, 1
Right.
1/4, 1 1/3,
Gotcha.
something like that.
So had the reductions, and to be honest, the way the law is written, what it does is send the person who's building this to these tables with these reductions. So the current law allows those reductions. So it is concerning some people, but possibly not even providing what's more than what would have been there anyway for the townhomes. So we may be creating a whole bunch of concern and not actually solving the problem that we're trying to solve, which is how do we ensure that these guests aren't blocking someone else's driveway, or making some mom with 4 children have to park 2 blocks away to bring her groceries in. And I get that. So it is after 7 and we haven't solved this problem. But I think this is one of the thorniest ones that we have, so I appreciate the good discussion that we've had here. I promise this is not a permanent committee, and I do feel like we've made a lot of progress, and that, another meeting or two, and I think we'll be to let's go out and talk to our groups, and then maybe one more meeting after that. So are we game for February 23rd, which is 2 Wednesdays from now at 6 o'clock, not any other time? And sorry about that. Our goal will be, I think, to come back and talk about these final thorny issues, and I will ask Mr. Hargis if he can come back as well and have final versions of his issues. I am so grateful to Mr. McBroom for being here to be able to give us the reality checks on all of that. And we'll, if a miracle occurs, we'll get it all done at that next meeting, and then we'll go out and come back again.
Councilmember, I must tell you that the 23rd, we have a very large short-term rental appeal board.
Gotcha.
Whole day. Be our whole day.
It'll be a long day. So would we want to perhaps move it a day or two, or give it another week and move it a week later to the 30th? That'd be March 2nd. What makes the most sense? Another day in that week, or to give it another week before
That'd be 3 evenings in a row for you and I of council, and then this, which I'm fine with. I just wanted to remind you that
Right.
sometimes it's
If we move it to March 2nd,
fine with me.
okay, then, yeah, we're there, but Councilmember Parker and I will see a lot of each other. Okay, so if we do that, then I will just throw again one other thing out. I don't know that it necessarily is directly connected, but there is a fairly onerous bill at the state level. I don't know if they're watching what we're doing. I have tried to let them know that we have a group of all the stakeholders working on this, trying to come up with reasonable stuff, and so we don't feel like there is benefit to their trying to take our authority away. If any of y'all have connections at the state level, we would appreciate y'all letting them know that we got it covered. We're trying to do something reasonable, and we understand that there are some bills at the council level that concern them, and that we're talking about those.
We did have a big ask from the mayor's office for information, and I think we provided their lobbyists some very good and pointed information, and
Okay.
we'll just hope it yields. And if I may say this, we did not cover the overlay, and I'll make this very quick.
Okay.
In essence, what that suggests is that they do a zoning change to put the overlay in effect. Our discussions with zoning were that if you're going to do a rezoning change anyway, then why not just make a rezoning change whereby the NS is removed from the affected parcels or lots? And that way it's so much cleaner. I mean, it doesn't confuse the person that's trying to look at it. You don't have to consider the overlay. You just have that. It's almost like an SP, but you still have to go by the underlying zoning district for that code. So instead of instituting the overlay, just have a zoning change whereby the NS for those affected lots or parcels is removed.
Gotcha. Okay, so I think that's another thing to think about is overlay versus NS. And the goal there was simply to provide a process where someone could have a council hearing where the neighbors could show up and say, we really don't care, it's okay. And that mechanism would also happen in a rezoning to NS. So I think that's a good question. So we're not going to answer that one tonight either, but just to give the folks who don't spend all day thinking about zoning more vocabulary to work with as you think about that. Okay, so we're set to meet for March 2nd then. There are some homework assignments. I'll try to send out the notes very soon, so everybody will be able to remember what you need to be looking at, and I will try to get the information to you more than the morning of for the next meeting. So thank y'all for coming ready to work. I appreciate it. All right, we're adjourned. We'll see you in 3 weeks.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.